You and I had talked about, though, what the Ninth Circuit kind of did this week in the Muñoz v. Department of State decision, which what happened this week is the Ninth Circuit decided not to rehear its Muñoz decision en banc. I think there were 9 judges who wanted to, but that didn't meet the threshold to rehear the case and decided again. I've been in touch with the attorney on the Muñoz decision. You know, they believe there's a possibility it goes to the Supreme Court. They knew the en banc challenge was coming. I mean, who knows? It's that important of an issue because it's about the doctrine of consular non-reviewability, which is the bane of all State Department consular attorneys' existence.
Yeah,
I could be wrong, but I think the last decision, at least that I can remember, is Kerry v. Din, about, you know, essentially, if I recall, the Department of State says Miss Din's husband supports terrorism and doesn't have to explain why.
yeah.
You can't sue the Department of State for denying a visa. It's essentially the doctrine of consular non-reviewability. But in the Muñoz decision, episode 128 of the Immigration Review podcast, the Ninth Circuit essentially said they have to give a facially legitimate, bona fide reason for denying, which is a small bar, but they have to do it timely. Like in the Muñoz decision, it seems like the consulate didn't tell Mr. Muñoz any real reason until like they sued in federal court.
Yeah.
And that was too late for the Ninth Circuit. At the end of the day, they said, like, we think you're a criminal because you've got gang tattoos. And by the way, we're not sure they're gang tattoos, you know, that old thing from Central America.
Yeah.
But they didn't even say why. They just like were denying, or if they were saying why, it was so vague that it didn't cut it. And the most important thing is that, so then by the time the consulate told them a legitimate reason why, a bona fide, facially legitimate possible reason why, it was too late. And you were already in federal court with full discovery, right? And a full, I guess, APA challenge to the denial of the visa. So getting over that hurdle of consular non-reviewability because the consulate didn't give a good enough reason quick enough, got full-on federal court proceedings. And that's the big deal of Muñoz.
Yeah.
It is an exception that can bore a big hole in this consular non-reviewability rule if the consulate doesn't act in time, if the Supreme Court doesn't overturn the Ninth Circuit in a petition for rehearing. I mean, in a cert petition. Now, does the Biden administration need to ask for cert? It does not. That being said, even if it doesn't, I'm sure, you know, eventually there'll be another district court decision that'll go to the Ninth, that could go to the Supreme Court. So with the doctrine of consular non-reviewability being so pretty firm in Kerry v. Din, I would imagine this issue goes to the Supreme Court eventually. But for now, especially in the Ninth, we have this ray of light to challenge consulate denials in the Ninth.
So,
Ninth, yeah.
So, I mean, it's kind of a good or bad thing that the en banc didn't list, and it just keeps things as they are.
It's a good thing. It's a very good thing. Oh, yeah.
And do you know why some of the, like, I just read a synopsis. The Law 360 had an article I read about it, Alan Diamante, and I think it's his firm suing on it. Alan Diamante is a great local lawyer in Los Angeles. Is there a reason why some of the judges recused themselves? I was like, why did these judges recuse themselves on this particular case? Did they hear it the previous time? Is that why?
I didn't.
Or, I don't know if you caught that. It was just the article mentioned.
I didn't catch it. I think though. I think that the judges on the panel recused from the en banc consideration. That wouldn't make sense, right?
Yeah.
But I'm not sure. That might be the reason. I'm not sure.
Speaking of this stuff, there's this part of INA 212, the inadmissibility statute, that I always found funny. So 212B says notice of denials. I'm
sorry, before you do this, you gave me no indication that you were going to be throwing statutes at me or that you were going to be sharing a screen. We have never shared the screen before. Look at this. Everybody see, look at this. Look at this. There's like 300 words on this screen right now.
It's INA 212. I have to actually, even though I don't even deal with it that much, I'm constantly reading this, trying to figure out what the hell is going on with the statute? But because they mentioned that the embassy didn't have to tell these people. In 212B, it says, subject to paragraphs 2 and 3, if an alien application for visa for admission to the U.S. or adjustment of status is denied by an officer, because the officer determines alien inadmissible under subsection A, subsection A being all the different admissibilities that there are, the officer shall provide the alien with a timely written notice that A, states a determination, and B, lists the specific provision or provisional law under which the alien is admissible or adjustment of status. Okay, so why they denied it, essentially, let's say why. But then this, paragraph 2, it says the Secretary of State may waive the requirements of paragraph 1 with respect to a particular alien or any class or class of alien, admissible alien. So statute says, like, USCIS has to tell you, but DOS could not if they don't want to. I'm like, it's kind of always kind of weird. It's like, why does the statute exist if it gives them that loop open? And the third part says paragraph 1 doesn't apply to INA 212A 2 and 3, which is like criminal statute, the criminal one and the security one. Security one, I mean, it's annoying that they don't always tell you because like you're just like caught. Like, why did they give us the now? It's confusing, but it's just a clear thing.
I think that what the Muñoz decision would say, with even for the INA 212, A2A, II, a CIMT, something like that, you still have to at least cite to the statute.
Yeah.
You still have to say. I mean, I would have to go back to Muñoz from many months ago and look at the interplay. I'm pretty sure they probably talked about this statute, but I don't recall them discussing it, and so maybe something is missed because all of that is there. But I think the Ninth Circuit would say you have to say what the statute is, and you have to give like a fact.
Yeah,
it's a low bar, but
yeah.
But you have to meet it, or you're in full-on federal court challenge.
You can't keep people something, even like it's just to leave people hanging like this is something. But I know they can always put them in admin processing forever, and that's a way to get out of doing this kind of stuff.
I get all worked up on Muñoz, but like state still holds all the cards.
State's too powerful when it comes to stuff. Yeah.